Welcome to Family Law A to Z with DBD.
Welcome to Family Law A to Z with DBD, a podcast from the Pennsylvania-based firm Dischell Bartle-Dooley. This series reflects the collective experience of the firm's family law team, including attorneys Mark Dischell, Elizabeth Billies, and Katie Lynn Daly, who work closely together to provide clear, practical guidance on the legal issues that impact your family and your future. I'm Lisa Mosby, your host, and today we're talking about prenuptial agreements in Pennsylvania, what they protect, and who should consider one. Joining me for this conversation is Elizabeth, we call her Liz, Billies. She's a partner at Dischell Bartle-Dooley. Liz practices all areas of family law, including preparing pre- and post-nuptial agreements. Liz is known for her thoughtful, strategic approach to both financial and custody matters. She focuses on helping clients plan carefully and move forward with clarity. Liz, it's great to have you back. Thanks for joining me again.
Hi, thank you so much for having me.
Liz, to start, can you explain what a prenuptial agreement is under Pennsylvania law?
Sure. So a prenuptial agreement, let's start with the name of it, is an agreement that you sign before you get married. So prenuptial. That sounds, easy enough, but what goes into a prenup is, and I'll use prenup or prenuptial agreement today. I think there's a lot of misconception what should and should not be in that agreement. But in general, it is an agreement between the parties that are going to be married as to, in the event of a divorce, and also for estate planning purposes, how they would like their money to be distributed. So if we get divorced, this is how we'd like to divide our assets. If one of us were to pass away, while we are still married, this is how we would like to divide our assets. And also, in addition to the asset piece, there is also the piece about whether or not there would be any alimony or temporary alimony awarded to either spouse in the event of a divorce. We do not include child custody or child support terms in a prenuptial agreement. This is simply any claims that would be what we call incident to a divorce, economic claims, such as equitable distribution and alimony. I always say equitable distribution, the dividing up of the stuff, and then alimony is the term that most people know. It's the after divorce support payment from one spouse to another. And then again, as I said just a second ago, prenuptial agreements also can cover estate planning issues, which I think a lot of people forget about that part. They're focused on the divorce part, but there also are a lot of estate planning provisions that I include in my prenuptial agreements as to how assets would be divided if parties were to, one were to pass away during the marriage. And in that event, how are we treating assets that maybe would have not been divisible in the event of a divorce? Would they now possibly be divisible or be available to the other spouse, which the surviving spouse, in the event of a death instead of a divorce? So they can cover a lot of things, but it really is an agreement where two parties say, I know what the law is on these issues. We're deciding to do something else. And it's really taking ownership of your money at the start of your marriage, so that you're not fighting about it at the end of your marriage in the event that a divorce would occur.
And then, Liz, who should realistically consider a prenuptial agreement today? Is it limited to just high net worth individuals?
So that is probably, I think, the biggest myth of prenuptial agreements is that it's only for the wealthy, it's only for the celebrities. And listen, those stories are great, like the celebrity stories about what's in or what's not in their prenup, or did they have a prenup? Like, those are wonderful, and obviously those people should have them, but they're not just for the celebrities and the billionaires out there. They are for anyone that is going into a marriage with assets that they would like to protect. I've done prenups for people that, range in ages. They have all different reasons for coming. Most of them, perhaps they owned a home that they purchased prior to the marriage, and they want to preserve that as their separate asset. Perhaps they themselves don't really have a lot of assets, but they believe they're going to inherit things in the future, and they want to make sure that those inherited assets and the increase in value on them are not divisible in a divorce, or they're part of a family business and they want to make sure that the family business is not going to be affected by their divorce. So I've done prenups for men, women, all ages. Some of them have been divorced previously. Some of them have never been married. So it really can be for anybody that has assets prior to the marriage that they would like to protect in the event of a divorce, and also have a little bit more ownership of how they would like to have them distributed in the event of a death as well. And if you're not sure if a prenup is for you, I'm not sure. I don't know if I have the right stuff. Is this worth it to me? Is it in my financial interest to get a prenup? Sometimes it's not, depending on what the asset pool is on the other side. I always recommend go have a consult with a lawyer. It's going to be likely a couple $100. You could save yourself thousands in legal fees in the event of a divorce, and or you would be protecting assets, thousands of dollars of assets in the event of a divorce as well. It's well worth your money to go pay a lawyer for a consult to see if a prenup is right for you.
Liz, I'm sure timing can matter significantly. When should couples begin that conversation about a prenup to ensure it's enforceable and thoughtfully prepared?
I would say I wrote an article years ago that was called "How to Ask for a Prenup Without Getting Dumped." Um, I think it's best for couples to have the conversation about whether or not they want a prenup before either of them has had one drafted. I don't think providing someone with a document that's already been prepared before you've had that discussion, I don't think that that is good for the relationship, and I don't think it's a good way to negotiate the prenup, because the other person might feel defensive because they feel like they've been not really part of the process or the decision making that a prenup is going to be signed in general. So I tell clients there's no hard and fast rule as to when it needs to be signed in advance of a marriage, but do not wait till the last minute. Again, it's not it's one more thing that the parties who are getting married have to think about. I always say, like, you'd rather be thinking about flowers right now than this prenuptial agreement. Come see the lawyer, go see the lawyer shortly after you get engaged. I think having the conversation about a prenup, if you've not actually had that conversation before getting engaged, which many people have, which is great. If that has not occurred, have that conversation, make the decision that a prenup is going to be signed. Go see a lawyer as soon as possible. They, give them your wedding date. Obviously, that's important for the agreement and also for the timeline of the preparation and execution of the agreement. And then get that done well before the wedding. You don't want to be doing this, 3 weeks before your wedding, when you rather be doing all the fun stuff that comes along with getting married and spending time with your family and friends as leading up to the wedding. There is no requirement in Pennsylvania that the other side have a lawyer. That's a common misconception that would make the agreement unenforceable. But, again, doing it in advance would give the other side the opportunity to go look for an attorney, have an attorney review it if they want to do that. And I just think giving everybody time, not do it at the end, just creates better feelings around the document in general, that it was done in a thoughtful way that benefits both parties.
And Liz, Pennsylvania law has requirements around disclosure and fairness. What tends to be most important in making sure an agreement will hold up if it's ever reviewed by the court?
Sure. So the number one way, I always tell clients, the number one way to get your prenup thrown out is lack of full disclosure of the assets and liabilities as well. Assets are usually what people are more concerned about, but you want to disclose. And the way I write my agreements is I have a Schedule A for one party and a Schedule B. And on Schedule A, let's say that's my client's disclosure, I'm going to have all of their different assets that they may have, the values of those assets, and the date that those values were generated. So oftentimes clients will say to me, but do I need to get an appraisal of my home? You don't necessarily have to do that. You can get a value off of Zillow. It doesn't have to, you can estimate based on your own thoughts on what your value of your property is. As long as the other side says, like, I agree to that value, that's okay. We don't have to be spending lots of money on real estate appraisals and jewelry appraisals and things of that nature. But you want to include every asset that you have, the value of same, and then also the date that value was generated. That's very important for both sides to include that. You also want to disclose your income. I recently dealt with a prenup that I did not draft. Let's make that clear. That didn't disclose income of the parties. Well, that matters too. And people may say, why? It's income. That's not an asset. Well, because income is the alimony is based on your income. And so if we don't put what your income is in the prenuptial agreement as well, that can be another lack of full disclosure. So you want to include, if you're a salaried employee, I make, $90,000 a year. I also generally recommend as good practice to attach the most recent tax return. I think that's helpful, again, for full disclosure. It also, particularly if someone owns a business that has a lot of that can be helpful to show income. W-2, you can attach the W-2 if you don't want to do the return. I just prefer doing the return. I am very much of the mindset it's belt and suspenders. Like, we never want an agreement to be thrown out because we didn't include something that was very easily includable. And I always tell clients, like, they don't want to provide certain information. Well, then your prenuptial agreement is going to be in peril, and it will likely be found to be unenforceable if you don't provide that information. So let's just do this once, put it all in the agreement. I usually also do include a language, what's called a waiver of full disclosure. So if someone misses an account, a small account, or again, I have language in my agreements that, hey, I didn't go out and get a fair market appraisal of this house. I use Zillow, that's okay. And I think having that language in your prenuptial agreement is really important. But the case law in Pennsylvania, that is what the Supreme Court and the Superior Court has really focused on is, was there full disclosure or not? That's really the most important thing, above everything else when doing a prenuptial agreement, is that disclosure requirement, and it's disclosure to the other side. It goes both ways. So making sure that your soon-to-be spouse is also fully disclosing their information as well. It's probably slightly more important that the person who has the money is disclosing, but really both parties need to be fully disclosing their assets and income.
And then how do prenuptial agreements interact with business ownership, inherited assets, and family property? You've touched on each of these a little bit, but can you give us more information on that?
Sure. Let's start with business interests. So there's a couple ways that business interests can be in a prenup, and there's different ways that you can address it. I just was working on one recently where I was dealing with a business interest, actually. A lot of times that is why someone wants a prenup. They may be okay with sharing the increase in value on retirement accounts and bank accounts, but their business is their baby and they don't want to share it, and they don't want that to be exposed in a divorce. They don't want to ever have to sell their business because of a divorce. And I understand that. So with business interests, I usually include language. One is that we want to make sure we have the full information regarding the business. What is your ownership interest at present? Are you do you own the whole business? Is there a partnership interest? What's your percentage ownership? What kind of business is it? Is it an S corporation? Is it an LLC? Make sure we have that language correct. What is the name of the business? That sounds easy, right? But a lot of people have a business name that is not actually the name of the corporation. Let's have all that name. We want to make sure we have really identified this business. Again, that full disclosure. So let's make sure we get all that information correct. And then things can happen with the business during a marriage that we want to contemplate how we would deal with it. So what if I sell my business and I sell it and I make money? Is that money not in the pot for distribution in the event of a divorce? We want to make that clear. That's usually the case. What people want, let's make sure that's clear. What if I buy more shares in a business? Let's say it's a family business and my parents own it and I'm going to buy their ownership interest. If I buy their ownership interest, is that those new shares, is that marital assets to be divided or not? That should be clear. What happens if I sell this business, but I buy a new business with the proceeds? call, successor entity. What if I just change the name of the business, but it's really all the same? It's really just, going from A to B. It's really the same thing. Like, that's all needs to be covered. So there's a lot of pitfalls in the business section of a prenup that we want to make sure that we're covering. Family interests, similar. So family business, kind of along the same lines of what I just discussed, is if I'm going to buy into a family business during the marriage, generally people do not want that to be divisible in a divorce. But what money did I use to buy that interest? If I use marital assets, does that now make that interest marital? Oftentimes the answer is yes. So what money am I using, to buy into that family interest or partnership? I also see a lot of clients have interest in family real estate. So they own a vacation home in the Poconos for Pennsylvania people. And they, how that often can increase in value. Let's make sure that is carved out for not divisible in a divorce. So those are a lot of family things I deal with, both as a lot of family real estate recently, but also family businesses. And then inherited property. Generally the inheritance in Pennsylvania is not going to be that core inheritance is not marital property, but the increase in value is. So oftentimes the prenup is going to say, no, I don't want that increase in value to be divisible in a divorce. That's mine. And so making that clear. If I know a client is in line for a very specific inheritance, I will put that in the agreement. So just, again, it's belt and suspenders. Like there's generic language that I usually include, but then if I know my client is going to inherit an interest in a family farm, had that once, or they have interest in a trust, you want to make sure that is specifically listed so that there's no question later on that the other side knew that inherited property was out of the pot. Also a good practice point, or this is more for the lawyers out there, is to get if it is trust, that it's, where the inherited property is in a trust, get those trust documents, make sure you're understanding what the trust language says, that you're naming the trust correctly. Is the trust just what's in the trust? How is money distributed out of the trust? You want to get all that information correct. So that, you're reporting it, you're disclosing it correctly in the agreement. Again, just don't want any issues on the back end. So really understanding what your client's assets are and asking them all these questions is just so important. And then for the brides and grooms to be out there, making sure that if you have this stuff, tell your lawyer. They need that information, and make sure you're disclosing it to them. It all should be disclosed, and then let the lawyer tell you what they need or don't need for the agreement.
And Liz, here's where I want to kind of wrap things up today. This has been a lot of information, and I hope we could get it out to those brides and grooms who are getting started.
Right?
Boy, most of this stuff
I know,
didn't
makes your
exist
head
when I was
spin
getting
sometimes.
married. It does. But life circumstances change over time. Can prenuptial agreements be modified after marriage, and how does that process typically work?
Sure. So prenups can be modified, but that has to be by agreement. There is no requirement for modification. I have this question a lot where people will say, well, if we have kids, can this be modified? Like I said, let's say I waive alimony, and then, life happens. We have 3 children, and one of us decides to be a stay-at-home parent. And now, I agree to no alimony, but I haven't worked in 20 years, and that's going to be a financial hurdle for me. The answer is, well, you can ask for a modification, but they don't have to agree to modify it. And I have no leverage to force them to, right? Because you entered into this agreement freely. There's no court at the end of the rainbow saying, yes, you have to modify, your agreement. There's no legal recourse in that way. So what I tell clients, and I've had this conversation a lot recently, about what happens if we have kids. And I tell them, let's think about that before we sign this agreement. Is there what can we do about that in this agreement now? And I actually was listening to another podcast recently where the host was indicating she has an agreement a provision in her agreement that is, in the event that one of us stays home with the children, she actually pays her husband X number of percentage from her business revenue for the year. I thought that was an interesting idea. I was like, oh, I might use that actually. So there's things you can do to contemplate, like if one of us stays home, if one of us gets disabled, like prenups, we do our best to speculate as to what's life is going to happen, but we can only speculate, right? And so trying to think of some of those larger possibilities is what I do with my clients. But the clients do have to realize that they are walking in to an agreement that, life is going to life, as they say. And so, you do your best to protect yourself, and that's all you can do. And if later on you want to modify it, it's an addendum to the agreement. And that's just as valid as the prenup as well. So again, full disclosure, still want that, but the addendum is the recourse to modify. And I've done those, and I think it's a great option for people, but we just can't, you can't rely on it, unfortunately.
Liz, this has been a great episode. Thank you so much for your insights. Folks, that's it for today's episode of Family Law A to Z with DBD. If you'd like to learn more about Elizabeth Billies or the family law team at Dischell Bartle-Dooley, visit dbdlaw.com for resources related to prenuptial agreements and long-term family planning. Thank you so much for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.